This is a hearing, a plea hearing on the state's motion to revoke community supervision or to revoke probation, and is being accomplished by remote video technology, teleconferencing technology, using the Zoom protocol. This proceeding is also being live streamed on the court's YouTube channel, to all of which is to comply with the Texas Supreme Court's orders and the rules and directives of the Office of Court Administration governing in-person hearings. With that announcement or those announcements, let me also announce that because this is being presented over YouTube as a live streaming event, I announce that all persons are expressly prohibited from recording this proceeding on YouTube or by any other means, electronic or otherwise. And that prohibition also extends to people who are participating in this virtual hearing by Zoom, except for the court reporter. And he is expressly authorized to make a recording of the proceeding, just like he would do if we were in in-person court. That said, what says the state?
State's ready, Your Honor.
And defense?
Defense is ready, Your Honor.
Mr. Luna, I'm going to ask the court reporter, who is a notary public, to talk to you about your signature on the stipulation of evidence. Actually, I may just do that. He is on screen and he is listening to us as well. There has been a document presented in the plea papers that is entitled Stipulation of Evidence. It bears a signature, and I'll ask Mr. Hanshew to hold that signature page up in front of the camera. Don't say anything while he is holding it up. Is that your signature on the stipulation of evidence, Mr. Luna?
Yes, Your Honor.
And in putting your signature on that stipulation, are you swearing that all of the statements in that stipulation of evidence are true?
Yes, Your Honor.
All right, that will conclude that part of it. Thank you, sir. Now let's proceed with the plea hearing. Mr. Luna, the state has filed a motion to revoke your probation. And the court's files indicates you have had that for a good period of time. Let's see. You have had a copy of the state's motion to revoke probation since at least January 7 of this year, 2021. So you've had it for more than 10 days, according to the court's records. Is that consistent with your memory?
Yes, Your Honor. It is.
Do you understand that the motion to revoke probation alleges that you have previously been placed on probation in this case? It further alleges that you violated the terms of that probation by setting out a specific or particular violations. And it asks that your probation be revoked and you be sentenced to state jail, or actually to the Texas Department of Criminal Justice. Do you understand that's what it alleges and claims and asks for?
Yes, Your Honor, I understand.
then understanding those allegations, to the allegations in the motion to revoke probation, how do you wish to plead? True or not true?
True.
Do you understand that you do not have to enter a plea of true? You have the absolute right to enter a plea of not true, thus requiring the state to bring their witnesses into court and prove their allegations.
I understand, Your Honor. Yes.
You also have the right to have a minimum of 10 days notice of the charges, and I've discussed that with you, and we now understand you've had more than 10 days notice. But there's a document handed to me with your signature that is entitled Waiver of 10 Days. And the essence of that document says you're giving up the opportunity to have more time to prepare, which means your case would be heard by me today. Did you understand that's what you were signing when you signed the waiver of 10 days document?
Yes, Your Honor.
And is that what you still wish to do?
Yes, Your Honor.
Mr. Darnall, your signature is also on that document. Are you joining your client in these waivers?
I do so join, Your Honor.
Then, Mr. Luna, let me discuss just a couple of other matters with you, most of which I already know the answer to because we've been over this before, but I just want to put it on the record. First, are you a citizen of the United States of America?
Yes, Your Honor, I am.
Where were you born?
Curry County, United Texas.
And do you consider yourself presently to be mentally competent
Yes, Your Honor.
at this time?
At this time, I do, Your Honor.
All right, sir. Do you understand what's going on in these proceedings?
Pretty much, Your Honor, yes, sir.
And have you had a chance to discuss these proceedings and the case, the motion to revoke probation against you, including the facts that are alleged and how that might affect your probation?
Yes, Your Honor.
Mr. Darnall, do you believe your client is mentally competent?
I do so believe, Your Honor.
All right, I accept that representation, and the court is familiar with Mr. Luna, and the court also believes that Mr. Luna is mentally competent, and I make that finding. Mr. Luna, are you satisfied with the legal representation you have received from your attorney in this case?
Not really, Your Honor. To be honest.
I'm sorry, go ahead.
Oh, I'm just being honest with you, Your Honor.
I know you are, and I appreciate it.
Yes, Your Honor.
The reason I asked that question is so that you could tell me of any legal deficiency or legal ineffectiveness that might affect your case or the plea agreement that has been reached. And so that's really where my question is going. Do you know of any?
Well, we had a heated discussion last year sometime before the cause number 10705 began, and it made me hire another attorney because of that reason. But, you know, the plea agreement, I agree with, Your Honor. Just, I'm not, trying to wait any more of the court's time. No disrespect to your court, Your Honor, none.
I understand. But the reason I asked, one of the reasons I asked that question is because if I give you the chance now to let me know that there is some legal deficiency or ineffectiveness in the attorney's work that affects your plea agreement and affects your sentence, while I can still do something about it, that means you will not be successful if you wait to some later date to say, hey, I get to do this all over because my lawyer didn't do what was supposed to be done, and that affected my judgment and sentence. Do you understand what I'm saying?
Yes, Your Honor, I do.
And so my question is there anything other than the disagreements that you alluded to that affects the outcome of your case?
No, Your Honor.
All right, sir. And again, I appreciate your honesty and your your frankness in discussing this with us. Then let me go further at this point in time and discuss the plea bargain agreement with you, since we have talked about it a couple of times. The plea agreement, as I'm looking at it, says you will enter a plea of true, as you have done, to the motion to revoke probation. It says no new fine will be added or will be imposed, that there will be reimbursement fees charged in the sum of $610 and a restitution obligation imposed in the sum of $2,580. The plea agreement, as I understand it, says you will give up your right to appeal as a part of this plea agreement. I left something out. It says also that you will be sentenced to the Texas Department of Criminal Justice for a period of 7 years, but you will be given time credits totaling 359 days against that sentence. Now, all of that is my understanding of the basic terms of your plea bargain agreement. Is that the same as your understanding of the plea bargain agreement?
Yes, Your Honor, it's the same.
And are you asking me to approve this plea bargain agreement?
Yes, sir. Your Honor, I am, respectfully.
And then let me ask Mr. Darnall, have I stated the plea agreement accurately as you understand it to exist?
You have, Your Honor.
And Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
All right, Mr. Luna, I announce to you and for the record that I will approve the plea agreement. And so let me pronounce that in cause number 10,705 for the case styled the state of Texas versus J. Waylon Luna, based upon your plea of true and the evidence stipulated to, I find that the allegations in the motion to revoke probation are true, that you have violated the terms of your probation previously granted, and that your probation should be revoked, and you be sentenced to the Texas Department of Criminal Justice Institutional Division pursuant to the plea bargain agreement that I have already said I will approve. With those statements made, let me ask you, sir, Mr. Luna, do you know of any legal reason why I should not pronounce the sentence at this time?
No, Your Honor, I don't.
Then, following your plea bargain agreement, as I said I would do, I hereby sentence you to serve 7 years confinement in the Texas Department of Criminal Justice, the Institutional Division. I order restitution to be paid in the sum of $2,580 and reimbursement fees totaling $610. And I do not assess any additional fine or fees. I also follow the plea bargain agreement and grant to you, Mr. Luna, 359 days of time credit against this sentence.
Thank you, Your Honor.
You're welcome. Do you have any questions at this time about the judgment and sentence?
No, sir, I do not.
Then those will be the orders of the court, and we will be in recess. Thank you, Mr. Luna. You may be excused from our hearing.
Yes, Your Honor.
And good luck to you, sir.
Your Honor, my condolences to Mr. Terry. Mr. Henshaw, his father passing.
He said thank you. Yeah, thank you, sir.
Judge, who do you want next?
Let's do Mr. Sebastian Gonzalez. And have Mr. Teeler talking in the hallway, so maybe he'll talk himself out. But don't let him talk to Mr. Luna.
John told me, I think John went and picked the plea papers up from the jail, and somehow Jay was close by and saw John when he picked the papers up. And Jay said to John, tell Mr. Smith that after I get out of prison on this one, I'm retiring.
That would be good.
Yeah. Yeah, I said to John when he told me this, I hope he means from his career of crime.
You want to do it first?
Judge, was there any court costs on, Luna's case at all, so I could put down on the court card?
There are no court costs, just the reimbursement fees of $610 and the restitution that I mentioned.
Yes, sir, thank you.
Thank you, sir.
Mr. Gonzalez,
Yes, sir.
let me turn my video on, sorry. Can you see this stipulation of evidence?
Yes, sir.
Did you go over that with your attorney?
Yes, sir.
And is that your signature?
I can't see it.
A little higher, Terry. A lot higher, a little higher. There.
Yes, sir.
Do you swear that everything in there is true?
Yes, sir.
I'm going to show you another stipulation in the other case. Did you go over that with your attorney?
Yes, sir.
And that signature right there, is that your signature?
Yes, sir.
Do you swear everything in there is true?
Yes, sir.
Thank you, sir.
So just.
Yeah. Okay.
Judge,
Yes.
Ms. Crystal Plunkett is in the jail lobby. Are you willing to hear her case today?
Who? Oh, Ms. Plunkett,
Yes, sir.
State, you agreeable?
Sure. That was an
Okay.
arraignment, right, from yesterday?
It is.
Okay.
Yeah, we've got about 2 more cases to hear, and I'll recommend whatever we're done here.
Thank you.
Yes, sir. Thank you.
Thank you all for your patience. I just wanted to make sure I didn't get anything messed up, so it took me just a little bit longer to get things in order. Call cause numbers 10,804 and 10,847. Each case being styled the state of Texas versus Sebastian Zenobio Gonzalez. Actually, 10,804 is styled the state of Texas versus Sebastian Gonzalez, it appears. Yes. The plea papers presented indicate that the defendant desires to enter pleas of true to cause number 10,804 and a plea of guilty to cause number 10,847. All of those pleas being entered pursuant to plea bargain agreements between the defense and the state. Before calling for announcements, let me also make this announcement. That is, this hearing is being conducted by remote video teleconferencing technology. We are using the Zoom protocol for that purpose. The proceedings are also being live streamed on the court's YouTube channel in order to comply. All of that is in order to comply with orders from the Texas Supreme Court and rules and directives from the Office of Court Administration regarding in-person hearings during the time of this pandemic. With those announcements, I should also announce that everyone who is a part of this proceeding and anyone who might be observing these proceedings on the court's YouTube channel are expressly prohibited from recording any portion of this proceeding on YouTube or Zoom or by any other method whatsoever, except for the court's official court reporter who is authorized to make a recording of this proceeding, which he will do and is doing, just as he would do if we were in person in live courtroom. With those understandings, for purposes of these pleas, what says the state?
Ready, Your Honor.
And the defense?
Ready, Your Honor.
Sir, are you Sebastian Zenobio Gonzalez?
Yes, sir.
And are you also sometimes just known as Sebastian Gonzalez?
Yes, sir.
Mr. Gonzalez, in cause number 10,804, the state has filed a motion to revoke probation in that cause. It alleges that you were previously placed on probation in that case. Further, it alleges that you violated that probation in very specific particulars. and it asks that your probation be revoked and you be sentenced accordingly. Are you aware that the state has filed such a motion to revoke probation?
Yes, sir.
You also have, well, let me ask you this way. To the allegations in the motion to revoke probation, how do you wish to plead? Guilty or, true or not true?
True.
Then let me talk to you about cause number 10,840. That's a new indictment that alleges unlawful possession of a firearm by a felon, which is a third-degree felony as it is alleged. An indictment has been returned making those charges in that cause number. You have the right to have someone read that indictment out loud to you here in court, even in this electronic virtual court. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand that it does charge you with a third-degree felony offense of unlawful possession of a firearm by a felon?
Yes, sir.
To that charge in cause number 10,840, how do you wish to plead, guilty or not guilty?
Guilty.
And do you understand in both of these cases, 10,804 and 10,840, you do not have to enter pleas of true and you do not have to enter pleas of guilty. You have the absolute right to enter a plea of not true and a plea of not guilty. And further, you have the right to not have it held against you or used against you just because you might exercise that right. Do you understand that?
Yes, sir.
You also have the right to have a minimum of 10 days notice of the charges against you and to have a reasonable period of time to have notice of the allegations in the motion to revoke probation. I have been given documents entitled waiver of 10 days and waiver of defendant, one in each case, one in waiver of 10 days in the revocation case and waiver of defendant in the new indictment case. And they say you do not want to have any more time to prepare, whether you have had enough time under the minimum amount allowed by law or not, you're ready to have your cases heard today.
Yes, sir.
Is that what you want to do?
Yes, sir.
Also, in cause number 10,847, the new indicted case, the law says you have the right to a jury trial, even if you plead guilty to that charge, as you have told me you wish to do. Do you understand you have the right to a jury trial?
Yes, sir.
And do you understand by signing the waiver of defendant document, you're telling me that you want to give up the right to the jury trial and just have your case heard today by me without a jury?
Yes, sir.
Mr. Darnall, your signature is on each of these waiver documents. Are you joining your client in these waivers in each case?
I am, Your Honor.
And Mr. Smith, your signature is on the document waiver of defendant in 10,847. Is that evidencing that the state is joining in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, Mr. Gonzalez, I will accept the waivers in those cases, and I will proceed to discuss other matters with you. Let me start by talking about the range of penalties that you face in cause number 10,847, the possession of a firearm case. The range of penalties for that case, a third-degree felony, runs from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice. And it also carries the possibility that a fine could be imposed. And if so, it would be in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face if convicted of that charge?
Yes, sir.
I mentioned also that I'm aware that a plea agreement exists in your case or cases. I do not have to follow the plea agreements. I have to tell you if I'm going to follow the plea agreements, because if I do not follow them, then you have the right to take back your pleas. And further, you have the right to not have those pleas used against you if we went further with your cases. But on the other hand, if I do follow your plea agreements, then that means you will be bound by the terms of the plea agreements You cannot change the terms or get out of the terms later by appealing your cases. Do you understand that if I follow your plea bargain agreements, you cannot appeal?
Yes, sir.
Now, I left something out and I don't want to leave anything out. I made that last statement based upon provisions in your plea bargain agreement that says you're giving up the right to appeal. And ordinarily, you do have the right to appeal unless your plea agreements say you are giving up those rights to appeal, which your plea agreements say. And based on that, that means if I follow your plea agreements, you cannot appeal. Do you understand that?
Yes, sir.
All right. Now let's go further in these proceedings, and let me ask you some questions I'm required by law to ask. First, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
Little Rock, Arkansas.
My next question asks, do you consider yourself presently to be mentally competent?
Yes, sir.
Do you understand what's going on in these proceedings?
Yes, sir.
Have you had a chance to talk with and visit and cooperate with your attorney in discussing the case in cases and preparing to defend against the charges? Have you been able to do that?
Yes.
And have you been able to understand the advice your attorney gives you about the law as the law applies to your cases, these two cases?
Yes, sir.
Mr. Darnall, do you believe your client is mentally competent?
I do believe, Your Honor.
All right, I accept that representation. It's obvious to the court that Mr. Gonzalez is mentally competent, and I make that finding. Mr. Gonzalez, my next question asks, are you satisfied with the legal representation you have received from your attorney in these matters?
Yes, sir.
And let me explain why I asked that question, because I'm not trying to say you wouldn't be or you shouldn't be satisfied. Instead, I just asked that so you would have a chance to tell me if you were satisfied or not satisfied, so I could look into that. And if there were any legal deficiencies or legal ineffectiveness, perhaps I could get those corrected so it wouldn't have an effect on your case. But I should also tell you that since I do give you the chance to tell me if there is any problem with your attorney's representation, so I can get those problems corrected, that necessarily means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. In other words, now is the time to tell me if you think that exists. Do you understand?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation you received in these matters?
Yes, sir.
One other area of inquiry, I have to be satisfied that the decision to plead guilty is your decision based upon your own free and voluntary will. And so I ask you these questions. Has anybody threatened you or forced you or tricked you or in any way tried to make you plead guilty when you would not otherwise do so? Has anybody promised that you would get something of value, promised to give you something or pay you something to get you to plead guilty when you would not otherwise do so?
Yes, sir.
Are you telling me then that you're pleading guilty to these charges because the truth is you are guilty of these charges, and that's the only reason you would plead guilty to such a charge?
Yes, sir.
All right, those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, in each case, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in its respective case.
All right, Mr. Gonzalez, let me talk to you about these stipulations of evidence and discuss a couple of general rules that apply. Many of them in your favor. First, I tell you the state is required under law to present some evidence tending to show your guilt, even though you plead guilty. And that's to make sure that another right that belongs to you is in fact observed or provided to you. That other right is called your right to confront the witnesses against you. That just means you have the right to make the state bring their witnesses into court so you can see them and hear them while they testify. But these stipulations of evidence say you're giving up that right in each case and telling the state they don't have to bring those witnesses into court. Did you realize that's what you were doing when you signed the stipulation of evidence?
Yes, sir.
Also, each stipulation says you're giving up your right to remain silent and your right to be free from self-incrimination, which, by the way, is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because each stipulation is a judicial confession wherein you admit that all the material allegations in the new indictment and in the motion to revoke probation are true, that you committed the offenses and or the violations just as they are alleged. Did you realize you were confessing to these offenses and violations of probation when you signed the two different stipulations of evidence?
Yes, sir.
There are also some financial statements. That is, you're aware of court costs in the new case of $290 and reimbursement fees to the county in the sum of $675 in the new indictment case, and that there are reimbursement fees totaling $610 in the revocation case. Did you realize those were in the stipulations when you signed them?
Yes, sir.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in each case.
State rest, Your Honor.
Defense rest as well, Your Honor.
State closes.
Defense closes as well, Your Honor.
Then, Mr. Gonzalez, let me discuss with you the plea bargain agreements to make sure I understand them the same way you understand them. In the revocation case, the plea agreement says you will enter a plea of true, as you have done. It says that's going to result in a 2-year sentence to state jail with no additional fine being imposed, but reimbursement fees of $610 being imposed. The plea agreement also says there's a restitution obligation to be imposed in the sum of $2,985. The revocation case also says you will be given back time credits of 167 days. And each of the plea agreements say you're giving up your right to appeal, as I have already discussed with you. Now, in the new indictment case, the plea agreement says that you will plead guilty to that indictment as you have done. It says that's going to result in a 5-year sentence to the penitentiary with court costs being assessed in the sum of $290 and reimbursement fees totaling $675 to be imposed. As I've already said, that case also says you waive your right to appeal. It further says that you will be given back time credits in that case totaling 35 days, and the sentence in cause number 10,847 shall begin when the judgment and sentence in cause number 10,804 shall have ceased to exist. That means that the 5-year sentence will be stacked on top of the 2-year sentence in state jail. Now, that's my understanding of the plea agreement in your plea agreements in your two cases. Is that the same as your understanding of these plea agreements?
Yes, sir.
And are you asking me to approve these plea agreements?
Yes, sir.
Mr. Darnall, have I stated the plea agreements accurately as you understand them to exist?
You have, Your Honor.
Mr. Smith, have I stated the plea agreements accurately as you understand them to exist?
Yes, Your Honor.
All right. Mr. Gonzalez, I announce that I will accept and follow your plea agreements as presented. And so let me evidence that by signing them. Therefore, I announce in cause number 10,804, based upon your plea of true to the motion to revoke probation, I find that the allegation, and based upon the stipulation of evidence in that case, I find that those allegations are true, that you have violated the probation as alleged, and that your probation should be revoked in that case. And in cause number 10,847, based upon your plea of guilty to that charge and the evidence stipulated to in that charge, I hereby find that you are guilty of the offense of unlawful possession of a firearm by a felon as alleged in the indictment. Those pronouncements being made, Mr. Gonzalez, do you know of any legal reason why a sentence should not be imposed at this time?
No, sir.
All right, and cause number 10,804, I hereby sentence you to serve, as per your plea agreement, 2 years confinement in Texas Department of Criminal Justice State Jail Division. Order you to pay restitution totaling $2,985 and reimbursement fees totaling $610. Your thumbprint is required and is affixed to that judgment and sentence. In cause number 10,847, also pursuant to your plea bargain agreement, I hereby sentence you to serve 5 years confinement in the Texas Department of Criminal Justice, the Institutional Division. I assess court costs in the sum of $290 and reimbursement fees in the sum of $675. I also grant to you time credits totaling 35 days as per your plea bargain agreement. And I order that the judgment and sentence in cause number 10,847 will begin when the sentence in cause number 10,804 ceases to operate. Your thumbprint is also required on this judgment, and it has been affixed thereto. Do you have any questions regarding any of the matters we have been taking care of here in court this afternoon, Mr. Gonzalez?
No, sir.
Then that concludes your hearing today. And you may be excused. And let me wish you good luck and express that it's my hope that you will never have to appear in a criminal court again.
Yes, sir.
Thank you, sir.
Thank you.
Judge, it may be a minute. We are working on Taylor, getting him ready.
All right. Do your best work.
That doesn't sound good.
Your Honor, may I take a comfort break right quick?
Yes, sir.
Thank you. I'll be right back.
All right. Thank you.